Hello, welcome to the next season of Frenemies, season 4. I'm happy to kick off the next season called Oh My Acronym Privacy Regulations because we are about to head into a series that is full of lots of acronyms that we hope to explain what they mean and how they might impact your business. So welcome to episode 1. My name is Emily Voorhees. I'm an associate on the privacy team. And the first privacy regulation that we wanted to share with you is all about children. And it's specifically the Children's Online Privacy Protection Act. We will abbreviate that to COPPA, so it rolls off the tongue a little easier. And we're focused on children under the age of 13. Now, as marketers, your job is to reach the widest audience and produce product that is of interest to a wide variety of people and ages. But we do want to point out the number 13 for a specific reason, because there are federal regulations that come into play that would impact your marketing strategy. And so today, we're going to dig deep into COPPA. What COPPA 101 really is telling you about this federal law, how it impacts your business, and specifically why is age 13 so important. We might hear it mentioned when you talk to attorneys, and through that we'll tell you about COPPA, what you're required to do if you're subject to COPPA, the requirements of compliance, and then finally wrap up with how COPPA is enforced. So scene one, let's set the stage of the background. What's so special about age 13? Well, age 13 was picked by Congress in the year 2000 when the internet started to take off and become popular and become an avenue to reach new and wider audiences. The federal legislature realized that, hey, there are children using the internet and their parents might not know what they're doing and what information they're sharing online with companies when they're using different platforms and offerings. So in the year 2000, Congress adopted the Children's Online Privacy Protection Act to basically give parents more visibility on what their children are doing. So Congress selected the age of 13 to be the standard for 13 and under. Those are the children that need the most protection, that maybe don't understand the impact of information that they're sharing online, that maybe don't have an appreciation for protecting their own personal privacy. And so those children specifically of that age group needed the most protection, and that protection comes in the way of having parents involved. And so the goals were to increase parental involvement, to know what their children are doing online to protect their children's privacy, and making sure that if information is collected about a child under the age of 13, that information is kept secure, and the method of collection is something that parents have visibility to know what information is going out the door. And then finally, a final goal of COPPA is to basically limit the situations in when companies can collect information about children without parental consent. So giving parents a voice and awareness of what their children are doing online is really the goal that to keep in mind as we talk through in the next slides about how COPPA comes into play and what is required. It's important to keep the goal in mind that you can still reach out to children and you can still have children using your website or your product offering or service, but it's important to keep in mind who is your audience. And that's a question you obviously ask yourself a lot as a marketer, but that question has significance from a legal perspective too, because if you find that you're dealing with children under the age of 13, that is when you need to be asking some questions about, hey, wait, I think I am required to comply with this thing called COPPA. What does that mean? So at the top of the slide, I have included one of my favorite quotes from Friends. They don't know what we know, they know we know. And the idea is that parents are not probably keeping up with the latest technology and the latest offerings, and their children might be doing things online and parents don't really know about it. And maybe that's intentional. Maybe children aren't we don't want their parents to know what they're doing. But the goal of COPPA is to let parents know. And so we let them know by following the different compliance obligations. So there's a few factors to set the stage of, okay, I know that there's this law out there that applies to children under the age of 13. How do I know as a company if what I'm doing is something that that might make me subject to compliance? So there are a couple of factors that I'm going to walk through of letting you know when you need to comply with COPPA. So the first category is if you're operating a website or an online service that's directed to children under the age of 13, that is going to make you subject to compliance with COPPA. So that sounds very simple, but let me break it down, because when you get into the weeds, it becomes harder to understand. So a website or an online service is what is defined in the statute, but it's a little broader. So that could be a mobile application, it could be an internet-enabled gaming platform, a plugin, an advertising network, internet-enabled location-based service, a connected toy, or some other Internet of Things device. Those all fall into the category of an online service. So it's more than just websites. Online service wording captures any touch point of internet collection of information from children. So be thinking through what services do I offer online that that this might be a factor that I need to think through. Who is my audience? And so that will give you the scope of what we're talking about here when we think about COPPA compliance. The second part of the factor one is that it's directed to children under 13. So how do you decide that something is directed to children? It's not an easy question to answer, and there's not a bright line answer for you here. So what I can tell you is that there are a number of factors that the federal regulators have specified to help you determine that your website or online service is directed to children. And so you apply these factors, and the more factors that tally up, yes, then the more likely you are to need to comply with COPPA. If you are a website that is selling only, alcoholic products, well, we know that there's age verification at the start of a website that offers those type of products because of regulations. Very unlikely to have a finding that that's a website directed to children. It's just not the subject matter that you would expect a child to be under 13 to be interested in. On the flip side, if you have an online game, like Pokemon Go, that there are children under the age of 13 are more interested in cartoons, animation, the visual and audio aspect of the content itself. All sorts of lends itself to, hey, that might be something that a child is interested in. And so that's sort of how you're trying to factor, where do I fall on this spectrum? I've given you the two extremes, but there's going to be several examples of falling in the middle and having to decide, okay, which way do I go? And to be considered directed to children. So I've already alluded to some of the factors in those examples. You'd be thinking about what's the subject matter of the website or the service that you're offering. The subject matter itself might be something that tells you, yeah, a child is probably going to be interested in what I'm offering. The visual or the audio content might give you another clue. If you're using animated characters or cartoons or other child-oriented directed activities, that's another factor to suggest that a child might be stumbling on your website or using your online service. Looking at the age of the models that you've selected, for if you're selling product and the models used in your product offering are young children or teenagers, that suggests that the product you're selling is something that would be of interest to a child. So thinking through, who have you used in your advertisements and who have you used on your website to advertise your services? That could even be someone who's not a teenager, could be a celebrity. For example, if you have Taylor Swift endorsing your product or somehow involved in a advertising campaign, then that might be a factor to suggest, Taylor Swift is popular with young teenage girls. And so maybe those 12 and 13-year-olds would be interested in your product because of who is promoting your product. So that might be a factor to help you decide, yeah, my website or online service is directed to children. And the final factor are the ads that you place on your website or service. Are the ads themselves content that a child would be interested in or would catch their attention? So like I said at the top, it's hard to know. It's hard to know whether your website or online service is directed to children under 13. But these factors sometimes help you as you're weighing whether or not you might be subject to compliance just based on the content of what you're offering in and of itself. The second way that you might be subject to compliance with COPPA is if you're operating a general website or online service and you're knowingly collecting personal information from a child under 13. So again, I'll break down this factor as well. So we've already talked about how a general website or online service is broad, and it could be a mobile app or a game. And so then let's say that you've made the decision that the content is not directed to children, but you find out that you have actual knowledge that you are collecting information from a child under 13. Actual knowledge would be demonstrated by the collection itself. Collecting means you're requesting, prompting, or encouraging the submission of information, even if that's voluntary. So maybe you ask users to provide their date of birth, or you ask what grade they're in, or what type of school they go to, if they're in high school or college or elementary school. That's not directly asking for age, but that piece of information would give you actual knowledge that the person providing the information could be under the age of 13. So in that situation, when you have you have some affirmative information given to you that gives you the idea that you might have someone under the age of 13, then you need to be thinking, okay, I have obligations under COPPA, and I need to talk to my lawyer about what I should do about that. I've been using personal information throughout this presentation, but I haven't really defined it. So, personal information can be the things you consider the obvious, like name, address, contact information, social security number. Those are the common views of what is personal information. But under the statute, it's a much broader definition. So it could be a screen name or a username, some persistent identifier that recognizes a particular user. So an IP address or a mobile device ID that is tied to a specific user, that's considered personal information. Could be someone's photograph or a video or audio file. So if you are a platform that offers a video or phone call conferencing center, then you would have those recordings that could contain a child's image or voice. Geolocation data is another example of personal information that you might collect. And then finally, there's a catch-all, and it's other information concerning a child or the parents of a child that's collected and combined with one of the identifiers that I mentioned above. So if you are, it's a broad definition. If you are tying in information to build a profile about a user, and it goes beyond just their name and their email. It's broader than that when we're talking about information that you're collecting from a child under 13. So then the final way that you might be subject to compliance is maybe, you've examined your website and online service, you feel comfortable that you're not, that those are not directed to children under 13, but perhaps you have, you use a third-party service that you don't control, but you provide content to that service. So one example is YouTube. If you have your own dedicated YouTube channel, what information are you posting on that YouTube channel? Are you posting advertisements or other videos that is directed to children? And so that is another way, it's probably a secondary way, that you might be subject to COPPA and have some obligations. And in fact, I mentioned YouTube because YouTube recently settled a complaint with the Federal Trade Commission, the federal regulatory body that enforces COPPA. They settled for $170 million. And the claim was that Google had violated COPPA by collecting personal information from children without parental consent. The idea being that YouTube gets ad dollars generated by people viewing content, and so some of those people would be children, and information was collected about children. So YouTube has put the burden on the content creator or the channel owner to specify to YouTube that the material you've uploaded to the channel is directed to children or not. And they're having channel operators make that decision, because otherwise there's just the volume of content on YouTube. It would be a tall order for one company to do that. So if you think about your social media platforms, think about your other online third-party services where you have content that's not hosted by the company, but hosted by a third party. That content, if you were the owner of that content, that would be a situation potentially where you would need to think through your obligations under COPPA. So those are the situations in which you might fall under the umbrella of needing to require with COPPA. And so to quote in scene 3, Monica and Phoebe, do you have a plan? And Phoebe did not have a plan. She had a plot. You should have a plan if you're required to comply with COPPA. And so this next scene, I will tell you about just generally the high-level requirements for compliance. And by all means, this is not an exhaustive list, and I probably won't be able to go into much detail on each of these requirements, but this will give you a flavor of what's required if I find a situation in which it's needed that I comply with COPPA. So the requirements are these. I've listed them on the slide, and I'm going to go through them one by one. So initially, the top requirement is to post a privacy policy. And you may have a privacy policy already for the company, so it might be a situation where you either amend that or revisit that and make sure that it's complete, or you may have a completely dedicated privacy policy specific to collection of information for children. And it's something you can work through with your counsel of what makes sense for your company. But you want to post something that is clear, comprehensive in describing the types of personal information you're collecting, how you're using it, your practices related to that personal information, and make sure that that is clearly available to any user, and particularly the parents who would be looking for this privacy policy. Then the next step would be providing direct notice to parents. So this is where it can get this is where the tension can come in between legal and marketing. You want the onboarding process of a customer, the sign-up process, to be simple and as clean as possible and quick as possible. But this is where COPPA could slow things down. And so that's a common frustration that we can work through with clients of how to go about providing direct notice to parents. But the key for COPPA, if you are in a situation where you're collecting information about children under 13, is getting obtainable, verifiable parental consent. So there is a long list of how you can go about getting verifiable parental consent, and there's some exceptions to the rule of when you need verifiable parental consent. But the idea at a high level is that you separately communicate with the parent that, hey, your child has tried to sign up for our service or has initiated an account. We want to provide you with our privacy policy and get your permission to move forward. So that's how the parents are able to be put on notice that their child is submitting information to your company, and then the parent has the choice of whether to permit and consent to that information being given to the company. Other requirements would be providing the parent with access to the child's personal information. So having a mechanism in place internally where if a parent submitted a request to review the information you collected about the child or to have the information deleted, that you have some internal process in place to respond to that parental request. Another requirement is that it's not set in stone. This one-time parental consent could be revoked, and you have to provide the option for a parent to opt out if they decide later down the road that they want to prevent the further use and collection of the child's personal information. So it's not a one-and-done situation. You need to have the internal processes in place and build those processes in place to be able to contact parents, and then have mechanisms for parents to contact you if they later decide to exercise some of those rights. Then finally, once you have that parental consent, you've collected the personal information of children, COPPA has an affirmative obligation for you to maintain the confidentiality, security, and integrity of the child's information. So this would be making sure internally that you've taken reasonable steps, probably working with your IT security departments to make sure that there are mechanisms in place to protect the data that you have collected. And we've seen in recent years the Federal Trade Commission bring enforcement actions against companies who have failed to implement those appropriate security procedures. And as a consequence, they have had a data breach that exposed the information of children online. And in those situations, the Federal Trade Commission has brought regulatory enforcement action to say that the procedures were not reasonable to protect children's information. So much like health information or social security numbers, collecting information about children under the age of 13 is okay if you follow these steps and you find ways to protect that information and data. Then finally, the last requirement is to retain the personal information for only as long as necessary. So, there might be a great temptation to hang on to this data for a while. Data has value, learning about customers and being able to harvest that data. But COPPA is protective of the information that you collect about the children under the age of 13. And so having a plan internally about how long you retain that information and why you need to retain it, and then deleting it when you no longer need it, is a requirement that you would also need to think through. So now that we talked about what COPPA is, when it might be applicable to your company, and just at a high level what's required, in scene 4, let's shift gears and talk about the real upshot of why this matters. And it's laws wouldn't be followed if they didn't have an enforcement mechanism in many cases, because this is really the teeth of the law of why it's important to do all these things. As frustrating as it might be, as much as it might slow down the process or require you to take additional steps that slow down your sign-up process for bringing on new customers. Aside from that, it is the law and it is a requirement. And so we'll talk about how COPPA can be enforced. And the penalties can be harsh. So to wrap it up with my final quote from Monica, I need you to be careful and efficient. And remember, if I am harsh with you, it's only because you are wrong. And I can envision the Federal Trade Commission or a state attorney general saying something along those lines if you were to collect information about a child in the wrong ways, without that parental consent, without following the requirements. It is a law that's enforced by regulators. It's not a law that would be a private right of action. This is where you would have lawsuits. This is the Federal Trade Commission at the federal level, or the state attorney general, that would have ability under the statute to bring a claim. And there's a strong track record of enforcement activity. The FTC brought 30 COPPA cases from 2000 to 2019. 30 might sound like a low number, but I will say in terms of trends, the current Federal Trade Commission leadership takes COPPA very seriously. And so it's definitely had a renewed focus in recent years. And so it is something that is, even though it was adopted in 2000, it is still around, and it is still something that should be factored in. And through those 30 enforcement actions, the FTC has collected hundreds of millions of dollars in civil penalties. Just to give you a general feel of what enforcement might look like, the regulatory body would lodge a complaint. They would, if they found out about an issue, they would lodge a complaint and an investigation. If that investigation reveals wrongdoing or non-compliance, they can do a number of things. The FTC can require you to delete data. They can issue orders that the business must stop certain activities going forward. They could issue orders that you must change your business practices going forward. And then if you didn't follow those orders, then there would be penalties involved with not following those orders. So, it's not a good place to be to have a regulatory entity supervising what the company is doing and monitoring compliance. If you were to violate one of those orders, the statute does provide for fines. The statute allows civil penalties of up to about $43,000 per violation. And so the amount of that penalty would be based on a number of factors. It's the egregiousness of the violation. If you had previous violations in the past, then subsequent violations would be treated more harshly than potentially the first one. They are looking at the number of children involved, the amount and type of personal information involved, how it was used, how it was shared, the size of the company. And so they use all those factors to tailor what the appropriate fine would be. And so and per violation would be not just the actual activity. It's potentially how many kids were involved, how many times did you collect information in the wrong way from children. So it can be a figure that adds up pretty dramatically. As I mentioned, the enforcement action with a settled for $170 million, YouTube. So that's it's a penalty that can add up, and so it makes it important to take all of this to heart and seriously, even when it can be frustrating to hear no, or to hear from your lawyer, like, we have to think about this a different way or do this a different way. This is what the legal department is trying to protect you from. And with that, I would like to wrap up this episode 1 of season 4, and I hope you tune in for the remaining episodes where we talk more about more acronyms and privacy. Thanks.